Good evening, everyone. At the outset, I just want to apologise for the failure to launch on the live webinar. That old chestnut of technical issues. Hopefully you can still find this recording valuable, and thank you for your patience if you're taking the time to actually watch this. My name's Rebecca McLeod. I'm the practice leader of Watts McRae Northern Beaches office. Watts McRae's been around for 40 plus years. We practice exclusively in family law. I've been practicing law for about 16 odd years, about the last 11 of which has been exclusively in family law. I am the definition of insular peninsula, born and bred, haven't beaches. I've got a young family, and between work, family, friends, soccer, sport, all that stuff, that fills up my calendar. I'll hand you over now to Janine to introduce herself, my colleague.
Hi everyone, my name's Janine Goodwin. I've been practicing law for over 13 years now. I started my career out in a general practice law firm where I got exposed to a variety of areas of law. I've since honed in on family law and estate planning. I've lived on the Northern Beaches for the past 24 years, and I'm also lucky enough to be raising my young family in the area. And this is Chris.
This is Chris. And if you could just move 2 slides, please.
G'day all. Thanks for having me. Thanks for joining us. My name's Chris Gilmour. I'm a certified financial planner. Our business is Strategy First Financial Planning over on the other side of Brookvale in the Lifestyle Working building. We've been on the beaches for 19 years. We're self-licensed. We're independent. And we run a boutique business working with about 370 or so clients. We're the fiduciary for around $800 million worth of client investments that we're directly responsible for. Also a young family, with my wife and 2 little girls, so keeping me very, very, very busy. Yeah, but thanks for having me.
Great. So Chris is going to give us a little bit of a context around, and not it's the only reasons, but the agenda for this evening.
Next slide, please.
Thank you. So tonight we're talking about, as the title of the webinar is, future-proofing and protecting assets. We're going to talk about that in some specific scenarios. I'm going to talk about it in the context of entering into a relationship and during one. Janine's going to talk about it at the other end, if you separate coming out of a relationship, as well as in anticipation of death. And Chris is going to drop some knowledge on us with respect to some wider financial planning advice. So hopefully that will be quite a comprehensive webinar. We've got a lot to get through. Unfortunately, not being live anymore, there won't be the opportunity to ask questions live and that be answered, but we will share our contact details at the end. So please feel free to reach out to us. I do need to advise that tonight can only be general advice. Obviously, we would need to know your particular circumstances to be able to provide sound, accurate, tailored advice, which we don't have. And we also haven't vetted tonight's audience. So general advice only tonight. Next slide, please. Chris is going to talk about maybe some catalysts around when you might seek some advice.
Yeah, so usually when someone reaches out to us for advice, something's happened in their lives. So catalyst might be a new relationship coming out of an old one, either in the midst of separation, or maybe you've come out of separation and divorce and you're rebuilding things. It could be the death of a spouse, or a significant, let's call it a liquidity event. The sale of a business, sale of an asset, an inheritance. Maybe an insurance payout. But in terms of the people that I work with personally, a lot of my clients have gone through separation, divorce, and many widowed, and so that's hence the overlap in terms of the people that we work with. So that's the catalyst, usually why people sort of come to us. Our job is to help people then go ahead and make decisions to navigate that change, but also more broadly live a life that's aligned with what's important to us. Next slide, please. And usually where we start this is trying to understand what our values are. So if you grab a piece of paper and a pen, and perhaps you can write a few bits and pieces down here, but usually we start off with trying to understand what's important to us. So on the right-hand side here, we've got 8 areas of well-being. So physical, intellectual, spiritual, emotional, financial, occupational, social, and environmental. And they're not all going to be relevant to each of you, but usually we can grab maybe 4 or 5 of those and identify those as being pretty important to us. So as an example, I'm sure a lot of us might choose environmental, and that might be where we live. It might be more driven by the environment on more of a global level. It could be occupational, where you want to work in a job that really has purpose and meaning that you're passionate about. So start off with identifying those areas of or values that are important to you, and delving into those in a bit more detail. Now, once we've got an understanding of what that is, the next step is about getting a bit of clarity around what the future looks like. So I've touched on the fact that usually people come to us because there's a certain event that's happened in their life, and often it's hard to see past that. But importantly, when we're making decisions aligned with our values, we've got to be able to look past, what's on our plate right now. So I love this idea of the cross section of a tree, where each of those rings represents a different season, a different challenge, a different sort of period in our lives. And from an advice perspective, we're basically on a journey, right? It's not just, advice and it's over. It's very much about a journey. So trying to build out a timeline, and you can write this down, but build out a timeline, and at the beginning is where we are today. And then on that timeline, I want you to plot out things that are important to you, certain events in your life that are relevant. It might be, my kids are turning 28, and that's when I want to be able to help them get into the property market. It could be I've just hit long service leave and I'm going to go on that big trip that I'd always wanted to do. It could be retirement. It could be me having the choice to start working part-time. Whatever's relevant to you, put it on that timeline, and it helps to start give you clarity around, right, this is what my future looks like. So when I go back to my values and all my decision making, I can make those decisions through that lens of, right, well, this is what the future looks like. These are the things that are important to me. It's a lot easier to then go and make those decisions. So finally, it's then about building the goals, right? So we've got our values, we've identified and articulated what's important to us, right? Which not many people, go through that process. We've got a timeline, and then we build out some goals, which actually gives us something to strive for, something to target. And it's interesting that the achievement of those goals is what gives us financial well-being. If we don't have goals and we're just sort of moving forward with our lives, and we tend not to have that sense of well-being. So it really is an important step in the process, building those objectives. At the end of the day, they're going to drive our actions. And from an advice perspective, once we just go to the next slide, please. Once we've explored those values and what the future might look like for you, it's then about figuring out, all right, what do I actually do to make sure that I achieve those goals so that I actually live the future that I've set out for myself. So building a robust strategy, we might look at this as the blueprint. What do I do with my cash flow? What do I do with my existing assets? How do I manage debt? What do I do to be able to help pay off my kids' HECS debt, help them get into the property market? Building a robust strategy, actually working towards each of those. And importantly, what makes sense today, right? So a strategy that might be appropriate today may not make sense tomorrow if my circumstances have changed, or my situation changes, or legislation changes, or markets change. So those things are just constantly changing, which means we've got to sort of come back and figure out, all right, do I actually need to do things differently based on the state of affairs today? The next component of that is investment advice. So most of us have investments in some shape or form. Some of it is just our super. Some of it, it's cash in the bank. It could be an investment property, a number of other things. But how we invest our wealth needs to be aligned with the objective that we're trying to achieve, right? Otherwise, we're just investing for the sake of investing. We need to invest in a way that's deliberate. So we build a strategy for someone, and then make sure we're investing in a way that enables the future that we want for ourselves. Okay, so that's, I guess, the sort of the advice part of it. And if we could just jump to the next slide, please. The final part of it is the relationship. So everyone that we work with at Strategy First, it's a genuine relationship. We partner with people on that journey. It's not just, all right, address this issue and it's over. It's very much a journey. And I like to think of this as, it's you and us against the world, right? So you feeling like you've genuinely got someone in your corner, fighting those fights with you, who's got your best interests at heart, who understands you. Obviously, we understand what your values are. and we can help support those. So, feedback from our clients is that, they get four main things from that relationship. So financial well-being, peace of mind, genuine partnership and confidence, and all of that put together, we tend to be able to live a life that's pretty fulfilling. Okay, so we love what we do. We love partnering with people like you, but that's the reason why we do it. But tonight we're talking about, I guess, relationships in different shapes or forms or stages, and Rebecca's going to take us through binding financial agreements and bits and pieces that I don't quite understand, but thankfully Beck does.
Excellent, thank you. So segueing on from what Chris is talking about, which is asset protection, I'm going to hone in and talk about it in a specific context, which is asset protection in the context of entering into a relationship. The way we do that, or the way that that can be achieved, is through a tool and a document under the Family Law Act called a binding financial agreement. That is one and the same as what you might hear colloquially as the prenup or a BFA. I'll refer to it as a BFA tonight just for brevity, but they're all one and the same. So what is a BFA? It's a contract that you're entering into whereby you're saying, look, I'm stepping away from the legislative regime and I'm cutting my own deal, or we are cutting our own deal, as to how we're going to divide our assets when and if we separate. That document can also talk about spousal maintenance, and if we keep referring to the American terminology, that's the alimony bit. And we can also bundle in that document a release around claims on estates. So in the first part, I was talking about how we're going to divvy up our asset pool in the event of separation. This is technically amalgamating two documents, two deeds, into the one document called a deed of release. The gist of it is basically you say, when you die, I won't make a claim on your estate, and vice versa, and you give those mirror provisions. As I mentioned at the outset, in entering into a BFA, you're contracting out of the legislative regime. And so in order to do that in an informed manner, you need to understand what the legislative regime is to know what you're walking away from. I'll elaborate on that a little bit later, but the gist of what the legislative regime is that the law looks at what the contributions are that the parties have made and what the future needs factors are to work out a fair division of the asset pool. So that's what a BFA is. Next slide, please. So next question as to who can enter into a binding financial agreement. It needs to have that nexus of a domestic relationship, and it can be entered into in any phase of the relationship. So as I've listed there, prior to entering into a de facto relationship, during a de facto relationship, post separation in a de facto relationship, or if you're in the more traditional sense, pre-marriage, during a marriage, post-separation, and then once you're actually divorced. So you can enter into a binding financial agreement in all those scenarios. Tonight we're focusing on the pre-separation element around that. Janine's going to talk about the post-separation element, so I'm just going to be talking about the during the relationship and pre-marriage and pre-de facto. Next slide, please. So how can we use this BFA tool to actually protect wealth? What's the nexus and the synergy between tonight's subject matter? As I said earlier, what a BFA does is that it dictates, it sets out by way of agreement how you're going to divvy up your assets when and if you separate. Those terms can be whatever it is that you and your partner agree to. So I've set out a couple of examples there, but there's no rules. You can tailor it and make it whatever you like, so long as it's an agreement. So I've written scenario and example number one there, that it might be the traditional, you keep yours, I keep mine. If we acquire any jointly owned assets together, we divvy it up in proportion to the way that we contributed to it. So if you buy a property jointly together, you both chip in 50% of the purchase price and service the mortgage equally. It gets sold, you divvy up the equity equally, and you each keep your respective own individual assets. That's a real classic prenup or BFA. Otherwise, you can make it a bit more sophisticated, and I would probably say arguably fairer, and say, okay, well, this is the deal if we're together for 1 to say 20 years or 1 to 10 years or whatever time frame sits comfortably with you. And it might be that arrangement for the first 1 to 20 years where it's you keep yours, I keep mine. But once we hit a certain time frame, 20 years, 15 years, whatever sits comfortably with you, that's all bets are off, and we instead are going to submit to the legislative regime that factors in contributions and future needs factors. So that's another example of how you can structure it. The third example that I've put out there is to say you can have a BFA whereby you structure it contingent around children, for example, to say this is the deal if we don't have children, and this is the deal if we do have children, and then we subsequently separate. So they're just ideas, there's no rules around it. I'm just giving some examples. In addition to talking about how the asset pool can be divvied up, as I mentioned earlier, we can also include provisions in there around spousal maintenance. So spousal maintenance is the concept of, in the most common form, is paying someone like $500 a week, or it can be lump sum maintenance, which is technically a different, obviously that depletes from one person and gives to the other person, hence why we're talking about in the context of asset protection. So we can put in the BFA to say, for example, that no spousal maintenance is payable. Or we can say spousal maintenance will be payable for the first 12 months of $500 a week, or whatever it is. But the point being is that you can talk about it, agree upon it, and document it and make it contractually legally binding. So it removes all questions around what you might be liable for. I've talked about how it can also be a deed of release, the gist of that being to say, I won't make a claim on your estate when you die if you don't make a claim on mine. We can bundle that in there. Again, just to clarify, that's in a death scenario, obviously, whereas the spousal maintenance and the divvying of assets is in a separation scenario, but we can actually amalgamate both those objectives into the one document. As I've kind of been alluding to, the terms of a BFA don't necessarily have to be fair. Hence why the law says that it's absolutely critical that you are informed and you know what you're doing when you're entering into that deal. So you can cut a bad deal so long as you're knowing, like you might be getting the short end or the long end of the stick, but you just need to understand what the stick is and which end you're holding. Next slide, please. A common question that I'm asked by people in society or clients or otherwise is, oh yeah, but like they don't hold water, prenups don't hold water, do they? And my answer is yes, if they're done properly. The concept of a BFA is quite simple. You're entering into a contract to talk about how your assets are going to be divvied up when and if you separate, but the law around it is really sophisticated. There's a lot of technical requirements that need to be satisfied to make it airtight. One of those requirements is, as I was talking about before, to make sure that you've got extensive independent legal advice on the effect of entering into the binding financial agreement, the advantages and the disadvantages. As to the general advantage around entering into a VFA, it's certainty. You know what the outcome is going to look like. The general disadvantage is, I call it the crystal ball factor. You don't know what's going to happen in the future. So, for example, I'm sorry to catastrophize, but if you were to get cancer or something terrible, if you didn't have a BFA in place that said, oh, we each keep our own, then that party might be entitled to a larger percentage of the asset pool under that banner of a future needs adjustment. So you're contracting out of factors. You might be cutting a bad deal that prejudices you because you simply don't know what the future withholds. So that's on a very high level, the advantages and disadvantages. Another point around what are the technical requirements for a BFA to hold water? Non-disclosure of a material asset is a ground to set aside a BFA. And to put that in less legalese terms, let's say you've got a schedule attached to your BFA and it says, you know, I own this property in Manly Vale and I've got X amount of savings and my super fund's got this and I've got some publicly listed shares. But you forget to mention about your beneficial interest in some discretionary trust that it's your parents' trust and it's got 5 properties in it and it might actually be worth $5 million, but you forget to mention that because you think of it as your parents' trust, for example. That can be a ground to set aside a binding financial agreement. So hence why I say in crossing the T's and dotting the I's, disclosure is critical. Another critical component to make it legally binding is the circumstances around which you enter into them, and more specifically, so that everyone has ample time there's no duress. There's umpteen case law around cases around, like a wealthy husband putting a prenup under the nose of an international bride, and her family's flown out for the wedding, and she's obviously stuck between a rock and a hard place, and rightly so. The court said, well, she didn't really actually have a choice but to enter into that agreement. So it's about making sure that everyone, like I said, has got the time and power, for want of a better words, to negotiate terms if they're not comfortable with them. So in summary, my advice to clients is, yes, binding financial agreements are helpful. Do not cut corners, because it will not be worth the paper it's written on. If you're going to do it properly, or not at all is my summary on that one. Next slide, please. So I thought I would talk through a case study scenario to talk about, or to demonstrate, how having a BFA could impact you in terms of asset protection. So in scenario number one, we've got party A that comes into a relationship and they've got more wealth than party B. They're together for 20 odd years. They have 2 kids together. They're currently, parties then separate, and the kids are, say, 10 and 15. Party B forwent their career to look after the kids, but the parties entered into a BFA at the outset of the relationship that was that classic, we'll each keep our own. So upon separation, 20 odd years down the track, party A, who came into the relationship with more assets, they might hypothetically walk away with, say, 70% of the asset pool. And they were clever, and they included a spousal maintenance clause in there that says, I won't be liable. So in scenario number one, party A maintains 70% of the asset pool and isn't liable to pay spousal maintenance. Scenario number two, exact same facts. Party A came in with more. They had 2 kids. They're together for 20 years. Kids are aged 10 and 15. But the difference being is that there is no BFA. And in that scenario, the fair division of the asset pool would be quite different. It might actually be that party B is entitled to a larger percentage of the asset pool, that they walk away with, say, 55% of the asset pool, because it's a disparity in the capacity to generate an income, because they've foregone their career to raise the children, whereas party A has gone gangbusters. And party A might also be ordered to, or it'd be just and equitable that they also pay spousal maintenance to party B for a while. So 2 very different outcomes depending on whether or not there's a BFA in place or not. As I said, you can enter into a BFA at all phases of a relationship, and if the ship has already sailed, in the sense that you have already separated, not all hope is lost. We can still help you maximise and protect wealth, and Janine's going to share a little bit of information around how getting legal and financial advice can help you protect and maximise wealth.
Thanks, Beck. So as Beck said, turning our attention now to asset planning and
Next
protection.
slide, please.
Thank you. Through the lens of family law property settlement post-separation. So the key to negotiating property settlement boils down to being informed. And that looks like being informed as to what comprises the asset pool and what its net value looks like, being informed as to your entitlements, and being informed as to how best to structure the assets that you are going to retain as part of the property settlement that will help you suit your future better. I'm going to deal with each of those individually. Thank you. So next slide. Next slide. So being informed as to the value of the asset pool. So it's not always the case, but we often quite see that in the course of a relationship, one party just naturally assumes the role of Minister of Finance, and the other is either left completely in the dark as to the party's finances, or just has a very vague, incomplete understanding of what they are. This can be due to coercive control or financial abuse, but it doesn't have to be. There's circumstances we see where one person just has this natural ability, skills, and interest to run the finances, and the other party simply does not, or their plate is simply full with other roles that they're attending to on behalf of the family. Regardless, if you're the party without the control or the knowledge as to the family's finances, then negotiating blind can lead you to missing out on what you could otherwise be entitled to. And on that note, I've seen a client who recently came to me in an initial consult and said, I just want to settle for 50-50 because my neighbours separated. They went through a few years fighting in court and ended up that way anyway. And whilst 50-50 was deemed just and equitable in the circumstances of the neighbours' relationship and their contributions and their future needs, it wasn't the case of my client. And also, it was based on not understanding what his asset pool looked like and the contributions, where if he had taken time to go through the process of, and Beck mentioned this earlier, the duty of disclosure, he may have seen things differently. So in family law, there is a duty of disclosure, which requires both parties to disclose all of their current assets, liabilities, and superannuation. And you're not just entitled to being told about them, but you're entitled to citing primary source documents to substantiate the asset pool. So your family law lawyer can help you identify what is relevant disclosure to your matter. And the scope can look like seeing the other party's individual tax returns, company tax returns and financial statements, pay slips, bank account statements, and information regarding the value or balance of things like shareholdings, cryptocurrency, trusts, and superannuation. Next slide, please. So this relates to the client that I mentioned. So people separating may skip obtaining advice as to their entitlements and instead base their understanding on what they've seen family and friends go through. But whilst a particular outcome may not have been just and equitable in their circumstances, it may not be in your matter. So there's a 5-step formula the court uses to assess the party's financial and non-financial contributions coming into a relationship, during relationship, and post-separation, as well as any future needs of the parties, which informs the percentage split. So 50-50 division may not be appropriate in a matter where one party contributed more non-financially and have primary care of young children moving forward, or where during a short relationship, the other party received a large inheritance, which was used towards the purchase of a family home. So your family lawyer will apply the court formula to your specific fact scenario and can advise you of your likely entitlement range. You can miss out on hundreds of thousands of dollars by jumping to mediation or an agreement without first understanding what your entitlement range is. Rebecca and I have previously presented a webinar dealing with the law and process around property settlements in more depth, including unpacking that court formula. If you'd like a copy of the slides of the recording in that webinar, please reach out. Next slide, please. Okay, so now we're looking at being informed as to the structure of the property settlement. So at the first meeting we have with clients, we quite often ask them what their dream outcome looks like. And for those that own a home, it can vary from, I need to keep the home for the stability for my children, or I don't want to keep the home. There's too much maintenance, there's too many memories, or I just simply can't afford it. We often pause there to ask, how do you know whether it is financially viable or not? Have you spoken to a mortgage broker to find out what your maximum borrowing capacity is? Or have you spoken to a financial advisor to understand whether keeping or selling the home is best for your circumstances? So once you've got the advice as to your entitlements and you have a percentage split in mind that you're aiming to settle for, say 60-40, being 60% to you, then the question becomes how you're going to make up that 60%. So for example, is it looking like you are wanting to retain the family home by way of refinancing and buying out the other party? Or does selling the home and getting part of your percentage by way of cash from the net sale proceeds and the other part by way of equalising or transferring a portion of superannuation make more sense for you? So it is at this juncture that we'd recommend speaking to someone like Chris so that collaboratively we can achieve a property settlement that will set you up best for your future.
Yeah, I think that example there of the home is probably a pretty common one where I think we go into defensive mode, and the most offensive thing for us to do is to say, I just want the home. I want the family home. That's all I want. And that's my priority. And I think if you ask, like, we end up being asset rich, and we we then tend to be cash poor or cash flow poor as a result. And so it's about identifying what's important to us. Again, going back to those values, do I prefer the roof over my head, but have to, live off an oily rag, or do I want to, do I maybe compromise on the home that I live in, but enable myself to live a more, fulfilling lifestyle, if you like. So my first point here is being pragmatic and realistic. And this is I think it's a pretty challenging one and takes a bit of work and hand holding and education to sort of address this, but really understanding, what are my financial capabilities like? Like, what can I actually achieve with the resources that we've got here? And what do I need to compromise on? Because there is compromise always. So that's probably where I would start in understanding what my capabilities are. In terms of some of the practical items that we've got to think about, so superannuation, that's going to probably form part of the asset pool in almost all circumstances, I'd say. Things to be conscious of here is, we can't access our super until at least age 60. Some people think it's age 67 that aligns with the age pension age. It's actually age 60 under current rules. At age 65, we've got unrestricted access to it. So that's something that I would plot on my timeline. Age 60, that's when I can start accessing my super. So that might influence, the role that I see superannuation as in that pool of assets and how you might split it up. You'll see reference, out and about around self-managed super funds, retail funds, industry funds. We see all three of those in our practice. There's probably a fourth there, which is, I guess, a platform type of super fund built for advisors and their clients. But some of you might be stuck with an SMSF, maybe with an ex-partner, and you don't want to be a part of that SMSF. So the question is, right, how do I actually get out? And what does that look like? And then where do I put my money into if it's not inside this SMSF? Right, so we can help people navigate through that. I think by default, people think industry funds, are the best thing out there, and retail aren't. I would say it doesn't really matter. It just comes down to what makes sense for you. Obviously, costs are important, which tends to be why retail tends to fall behind the industry funds, due to costs. But we see all three of those across our business in terms of what they're, how appropriate they are. The next part of that, it sort of extends into our investments. There might be investment assets like investment properties, share portfolios, managed funds, term deposits, unlisted assets that you might need to make decisions around. And as I touched on a bit earlier on, the way that we invest our money, or the investments that we choose to take in our share of assets, you've got to hold them in a way that's very deliberate around what we want the future to look like, the objectives that we have. And I'll just use the example of an investment property worth $1 million that pays me, let's say, 35 grand a year after all costs. If I need 60 grand a year to meet my lifestyle expenses and actually pay the bills, having $1 million in a property doesn't actually pay me 35 grand a year. It doesn't allow me to do that. So you're then forced to sacrifice your lifestyle just because you're left with an asset that isn't suitable for you. So I would say, well, why don't we find an asset, or maybe sell that asset and reinvest it in something else that enables you to live a lifestyle that you've spoken about as being important to you. So again, investing in a way that aligns with what's important to you. So investing should be an enabler as opposed to causing you to have to sacrifice to align with a particular investment. But that can be a tricky place to navigate. Things like tax is an important consideration. Just using the family home and an investment property as an example, if you were to sell both of those, one's going to have no tax payable on it. One is going to be a taxable event. So the value of those two assets is different once you factor in tax, right? So you've got to be tax aware when you're thinking about, different investments and the role they play. Debt, as Janine touched on, is a really important part. How much can I borrow if borrowing needs to be a part of it? Usually it doesn't matter how much money I have. All right, if you've got a $5 million property, it doesn't mean you can go out and borrow a whole lot of money. It comes down to serviceability from a cash flow perspective. The banks want to know that you can pay them, when the repayments are due, and they will stress test your ability to pay that. So even though rates might be 6% today, they're going to assess your serviceability at 8.5%, 9%. Right. So understanding what our borrowing capabilities are is really important. So engaging a mortgage broker in that regard is really important, so we understand what we can borrow. That will then influence a lot of our other decisions as it relates to property. And then obviously servicing debt from a cash flow perspective is also really important as well. How much do I need to retire? So I've sort of touched on it a bit earlier, but for a lot of people, it's hard to see past, what's right in our face, what's on our plate today. So thinking a bit further down the path as to what our future looks like. Obviously, the choice to retire at some stage would be nice. I think it's a few years away for me, but I still want to plan for it today and make decisions that are conscious of that. So that sort of touches on the next point, which is risk and return. Risk and return are related. The more risk I take, to a certain extent, will determine the reward that I get. I should expect higher returns if I take on more risk. The important part of that is I've got to own that asset for long enough to be rewarded for taking on the risk. So again, just in that position of defensiveness, we've got to make decisions, investment decisions, based on the objective that we're trying to achieve. So if I've got a retirement objective, I've got to make sure I've got some assets that are invested in a way for that particular purpose. I don't want to invest everything just for today. Estate planning is the final one. Obviously, there's some pretty significant changes in circumstances, movement of assets. Estate planning is an obvious one that needs to be reviewed. So Janine, is probably the best person to take us through that.
Thank you, Chris. Next slide, please. All right, so in the asset planning and protection, looking or anticipating death, estate planning, things that we can assist with is the preparation of wills, enduring power of attorneys, and appointment of enduring guardians. So people often get confused as to when and how these documents come into play. And an easy way to remember is that your will comes into effect only once you've died, so on your death date, whereas your enduring power of attorney and appointment of enduring guardian are effective whilst you are still alive, but you can draft them in a way that they're only effective if and when you have lost mental capacity and cannot make decisions for yourself. So first, dealing with wills, you can help protect your wealth after death by having a will nominating who is to receive your estate. It is important at big stages of your life, including a breakdown of relationship, to review any will that you've got in place to ensure that the executors and the beneficiaries that you've nominated are still the most appropriate people. So we often see parents of adult children concerned that their estate will form part of the asset pool up for division should their adult child separate from their de facto partner or spouse. So we can help these clients in these circumstances by drafting their wills to include a testamentary trust, which with careful wording can exclude the inheritance as an asset up for division as part of that matrimonial pool. We also see parties who make provisions for their estate to pass to one another, but then they may be concerned that if the surviving party repartners or remarries and changes their will, that the children may miss out on the inheritance and that the new partner or spouse may instead be provided for. So what we can do in these circumstances is prepare what we call a will deed, in which the parties agree not to change their will without the consent of the other or without the consent of their estate, should the other party have already passed. Next slide, please. So an enduring power of attorney is set up for circumstances for if and when a person loses mental capacity and is unable to make legal and financial decisions for themselves. And this document appoints an attorney to do that for them. And an appointment of enduring guardian is set up for circumstances where a person loses mental capacity and is unable to make health and lifestyle decisions for themselves. And in those circumstances, the guardian nominated can make those decisions for them. For both of those documents, there needs to be sound mental capacity at the time of making the appointments for the appointments to be legally valid. And it's for that reason I call these set and forget documents, because you're preparing them and signing them at a stage in your life where you actually don't need them. You've got the mental capacity, you can make the decisions for yourself, but you're preparing them, you're having them signed, you're having them there for peace of mind, for in case you ever need them, and hopefully you don't. So it's important in the context of a breakdown of relationship for any enduring power of attorney or appointment of enduring guardian appointing an ex to be revoked, and for new documents nominating more appropriate attorneys or guardians to be entered into.
Unfortunately, we don't really have the capacity for the Q&A, but email us, call us. We offer free 15-minute consults. Chris, I'll let you speak to whether or not how you feel questions of that nature.
Yeah, pretty similar. It's about understanding whether we can add value through advice. Often people will come to us and they're not quite ready for it yet, but we can help give some general advice and guidance. Often it's also about pointing people in the right direction in terms of, all right, if I can't help, maybe it's a solicitor you need to talk to, maybe it's a mortgage broker you need to talk to first, maybe it's your accountant. So trying to help solve a problem, point you in the right direction if we can't help. If we can help, there's a process we go through there, but I think it was interesting how you talked about the Minister of Finance. We see that obviously pretty common from an advice perspective where there's the CFO or the person in that role. The approach that we take when we focus on values is that it gives a voice to both people when we're talking to a couple. It's not just driven by the person who understands the numbers. So giving that voice to two people, it means that the plan that you have is, there's equal buy-in. That's the approach that we take. So yeah, feel free to reach out. I think on the next slide, we've got a couple of QR codes, which should take everyone to our respective websites. So that's probably the easiest way to reach out or via email.
And I think what tonight has demonstrated is that taking that holistic approach of like you bring the legal side of it, you bring the financial advice side of it, can actually help our mutual clients be in a more protected, favourable, comfortable, whatever terminology you want to use, position when you've got that holistic advisors supporting you. So
yeah,
thank
great.
you.
No pleasure. Thanks.
Thanks everyone for your patience tonight. I'm again really sorry and embarrassed about the failure to launch. We're much better at being lawyers, I promise, and as is Chris being a financial advisor. Our contact details are there. Please reach out if we can help in any further way, but otherwise, thank you for your attention tonight.
Thank you. Bye.
Bye.